Okay, I think we might kick off. I think there's still some people joining slowly, but we will jump into it so we don't take up too much of your lunch times. Thank you so much for joining us today, everyone. My name's Stephen Schoninger. I'm the head of the Employment and Workplace Law practice at Avant Law. And today, my colleague Savannah Russo and I will be talking to you about some important updates that have been made to workplace laws. We are members of the Employment and Workplace practice at Avant Law. For those of you who aren't familiar with Avant Law, we have been we've been operating for a couple of years now. We are a part of the Avant Mutual group of companies, but we are a separate standalone commercial law firm providing legal services with an industry focus on doctors and medical practices, as well as the broader allied health community across a whole range of commercial practice areas, including commercial and corporate law, property law, wills and estate planning, and employment and workplace. So please don't hesitate to reach out to us if we can be of any help to you. Today, Savannah and I are going to be giving you an overview of some of the key updates relevant to the medical and allied health industries around the reforms made to employment laws. And there are four main topics that we'd like to cover off today. Very important changes around casual employment laws that Savannah will take you through. I will be taking you through then the right to disconnect that I'm sure many of you have heard about. There's a lot of press and media attention around that new law that's just come into effect in the last couple of weeks. I'll also then be talking to you about changes in relation to independent contractor laws, where we're really going back to the future in terms of looking at the tests of who is an employee and who is an independent contractor. And then Savannah's also going to talk to you finally about, very importantly, the criminalisation of wage theft in Australia from next year. So where it will become a criminal offence to underpay wages to your staff. These are what we consider, I suppose, the key reforms in the workplace law space relevant to today's audience. There are a whole host of other reforms that the laws have brought into place around enterprise bargaining and the regulation of the gig worker economy and things like that. So if any of those particular changes are relevant to you, please don't hesitate to reach out to us, and we'd be very happy to give you advice in relation to any of those topics. Very importantly, before we kick off, just an important reminder that everything we're talking about today is general information only and is not a substitute for obtaining specific legal advice relevant to your circumstances. A lot of the new law reforms are introducing complex multifactorial tests that are relevant to determining the classifications of types of workers and the types of worker you have in place. And so it is always important to get specific legal advice. I'll hand over to Savannah to get us started in relation to the changes on casual employment laws.
Perfect. Thanks, Stephen. Hi, everyone. So there have been several changes introduced by the Loopholes Act to casual employment laws. We had a bunch of changes in around 2021 to casual employment, and we've got another host of changes coming into effect now. So you're right to think that maybe you already dealt with this, but no, these are new changes that have come into effect. And these changes came into effect for all businesses on the 26th of August this year, so last month. So firstly, there's been a new definition of casual employment introduced. So under the Act, a casual employee is someone who has no firm advance commitment to continuing an indefinite work and is also entitled to be paid a casual loading or a specific rate of pay for casuals under either the terms of an industrial instrument, so that would be like a modern award, or under their contract of employment. So the new definition is very similar to the previous definition of casual employment, so there's not a huge change. The wording has simply removed the phrasing according to an agreed pattern of work from the definition. So the agreed pattern of work is still a factor that goes into considering whether or not someone is or isn't a casual, but it's no longer part of the definition, so it's no longer determinative. The really important change around the definition of casual employment is less about the words of the definition themselves and more about how the definition is applied. So previously, the terms of someone's contract was key to determining whether there was a firm advance commitment to continuing an indefinite work. Now, whether or not that firm advance commitment exists is determined based on the real substance, practical reality, and true nature of the employment relationship. So it's not just about the words of the contract, it's really looking at how is this working arrangement actually happening in practice? What's going on? And so it's not just the contract. So previously, having a best practice kind of casual employment contract was the most important thing a business could do to kind of mitigate the risk that one of their casuals was a permanent employee, in fact. And this is still one of, if not the most important thing, but it's not going to be determinative in and of itself. And so the court is going to look beyond the terms of the contract to say, how are you guys working in practice? What is the relationship between this employee and employer? Is there in practice a commitment to continuing work? Or is this person really a kind of permanent, really a casual employee, and it really is a kind of ad hoc relationship? So there are a specific list of factors that goes into considering whether someone is casual and whether there is that advanced commitment to work. That includes whether the employer can choose to offer work or not offer work, whether the employee can choose to accept or reject that, and importantly now, whether that actually happens in practice. So do you offer shifts to someone as a casual, and do they sometimes say, no, I don't want to take that shift? Do you sometimes say, no, we don't have any work for you? Or is there really that kind of regularity going on in the relationship? Another factor is whether there's likely to be continuing work available. So that's going to depend on the business's needs and kind of the future projection. If permanent employees of the employer perform the same kind of work that the employee usually performs. And I think this is a really important one for practices, because the reality is you will often have employees doing effectively the same role, admin employees, nurse employees, some who are permanent and some who are casual. So I think that's something that's going to be quite important for practices to look at, and also whether there's a regular pattern of work, as I mentioned before. So importantly, there are provisions in the Act to prevent a casual relationship from morphing or changing into a permanent relationship over time. And this is something that wasn't originally in the proposed bill, but after some pushback from businesses was introduced into the proposed bill, because businesses were naturally concerned that I might engage someone as a casual employee on day one, but after a period of time, our relationship might change and it might morph into a more kind of consistent, permanent style relationship. And there's a lot of uncertainty, therefore, as to, whether or not someone is actually a casual. And so as a result of that, there were new provisions introduced that are now part of the legislation that basically say, if someone is a genuine casual, they will remain a genuine casual until certain events occur. And so the events are either the employer and the employee agree to change the relationship and it converts therefore to permanent employment, or if the Fair Work Commission makes an order that the employee is treated as a permanent employee. So what this means in practice is that properly classifying an employee as either permanent or casual at the commencement of their relationship is going to be critical. And so really looking at when you're trying to hire someone, what does our business actually need for this role? Do we need someone who is coming in on a really ad hoc basis to fill in on sick leave when people are away or when things are really busy? Or in reality, do we need someone who's here 9 to 5 every Monday? If that's the case, you're really looking at a permanent relationship and not a casual relationship. So really assessing what does the business need at that point in time is going to be critical. And then also where there's a variation to the terms of the contract, reassessing whether that person still meets the definition of casual employment, or has there been some sort of change, I suppose, to the relationship that might mean they no longer meet that definition. Then the second change in the suite of kind of casual employment changes is there's new casual conversion rules. So previously, as you'd all know, there's a casual conversion process where employers are required to proactively offer casual conversion to employees who meet certain definitions and have been employed for a certain period of time. The new provisions introduce what's called the employee choice process. And so it's all in the name, in effect, that employers no longer have the positive obligation to offer casual conversion to permanent employment to casual employees, but employees have the ability to request casual conversion. And so employees have that ability after 6 months of employment for big businesses, so businesses with more than 15 employees, or after 12 months of employment if businesses have less than 15 employees. So at that point in time, the casual employee can give a written notification to their employer and say, hey, I no longer think I'm a casual, I want to convert to permanent employment. And then the employer needs to follow a prescribed process to respond to that that application. Now, the process is very similar to the existing casual conversion process. It's also really similar to the procedural requirements for responding to flexible work requests. So it's a process that a lot of you will be really familiar with, but it is really important that you meet those specific requirements when responding to a request. You have 21 days to do it. So jumping on it right away is going to be really important. And importantly, an employer can only refuse a notification on specific grounds. And those includes if the employee still meets the definition of casual employee. So saying, no, this person is still a casual employee, that they're not a permanent employee, or if there are fair and reasonable operational grounds to refuse the request. So it's going to be really important that you are really critically looking at if any employee does make a request, are they really a permanent employee? Is there a reasonable basis for us to refuse that request? And a reasonable basis isn't simply we want them to be a casual. There really does need to be genuine grounds. And where a dispute does arise, employees and employers can apply to the Fair Work Commission to resolve that dispute. And the Fair Work Commission can make an order to say this person should be made a permanent employee. And at that point, the employee would convert to permanent employment. So it is really important, particularly jumping on any request straight away. So you've got your full 21 days to tick all your procedural requirements. But the process is relatively similar to the existing process, except that the employee is the one that initiates that process rather than the employer. Then the third change is around the casual employee information statement rules. And so employers are now required to give the casual information statement effectively a bunch of times during the employment. And I certainly don't envy businesses who need to try and practically implement compliance with this one, because it's going to require a lot of diligence from management. So employers currently have to give employees the casual employment information statement at the commencement or as soon as possible after commencement of employment. So generally we recommend it goes alongside an employee's contract of employment. Now businesses are required to give the casual employment information statement at the start of employment. And then if you're a business with 15 or more employees, you also need to give the information statement after 6 months of employment, which is when an employee has the right to request casual conversion the first time. Then after 12 months of employment, and then again every 12 months anniversary of employment. So that's obviously a very significant burden on the admin side of things to make sure you're ticking that box in terms of giving employees the statements at the right time. For businesses with less than 15 employees, so small businesses, they need to be giving the statement after 12 months of employment. So at the start of employment and then after 12 months, and then that's it for those. But it's going to be really important if you're a business that's on the cusp. As soon as you tick over to having 15 employees, you're going to tick over into needing to give all your casual employees the statements at the start, 6 months, 12 months, and then every 12 months. So as I said, I don't envy the ones who are actually trying to implement this, because it's going to be quite difficult and it's going to require a lot of diligence. But it is really important because it is a civil remedy provision, which means penalties technically apply for a breach of this provision. In practice, we don't generally see employees complaining about just not being provided with an information statement, but we do regularly see this being wrapped up in other claims. So an employee might, for example, say, I was a permanent employee, they've misclassified me as a casual, plus they never gave me the information statement on this date, and this date when they were required to. So that's really where the kind of stick comes in, I suppose. Adds an extra layer to any claim from an employee. So it is really important that you are ticking those boxes and complying. Then finally, they've also introduced new anti-avoidance provisions in the casual, in relation to casual employment. And these are really similar to the kind of sham contracting provisions with independent contractors. And so it basically says that an employer can't dismiss a permanent employee to engage them as a casual employee, or knowingly make a false statement to a current or former employee with the intention of persuading them to become a casual employee. So this is really around effectively misleading an employee so that they agree to become a casual, or terminating them so that they become a casual. And importantly, there's a difference between a dismissal, so a termination at the initiative of the employer, and an instance where an employee might ask to become a casual and the parties agree for the employee to become a casual. That's a situation that can certainly be accommodated, but if that is arising, we do recommend you get advice just to make sure you're not falling foul of the anti-avoidance provisions. But that, of course, can be accommodated where it is a genuine request from the employee and there's no kind of pressure going on. But it's something to just be cautious about. And around the anti-avoidance provisions, any of those are all civil remedy provisions, and so penalties also apply for breach of those. So it is really important that you're making sure you're not kind of pressuring anyone and complying with those anti-avoidance provisions as well. So I suppose in terms of, and I know that's a lot of information to digest, so tips to kind of ensure compliance and tick the boxes around the casual changes. I think stepping back, and Steve and I were talking about this earlier, the provisions are making businesses think hard about whether or not to engage casual employees at all. And some businesses are making the decision that it's not worth engaging casual employees. It's just too hard to make sure you're ticking all the boxes. There's obviously still a place for casual employment, but I think what's really going to be important is thinking about what does the business need at this time? Does it really need that ad hoc filler that a casual provides? Or are you really looking for someone who's going to be here on a regular basis? And if so, why aren't we making an offer of permanent employment? Should we be making an offer of permanent employment? And I think attention is going to arise where an employee wants to be a casual, but the business is of the view that the role that they actually need is really a permanent role. And so I think it's really important that you get advice if that does arise, because you really need to be, there will be times when that can be accommodated, but there may be many times when you can't, and you do need to say, look, this is a permanent role. We can't adopt the risk of having a casual in this role. So I think classifying an employee correctly at the commencement of their employment is going to be crucial. And then at any time their contract is varied, in particular, if there's a variation around when and how they're working, reclassifying that employee and considering, are they still a casual? And this also might arise with purchasing a practice. So just because the vendor or the seller has classified someone as a casual doesn't necessarily mean they're a casual at law. So if you are purchasing a practice, you'll be wanting to look critically at those casual relationships and making sure they are genuine casual relationships. Also being very cautious around pre-employment discussions with potential casual employees. So don't guarantee a casual, and I think this happens a lot in practice, guaranteeing a casual employee a particular number of hours, days of work, particular kind of shift or shift pattern, either verbally or in writing, around in kind of that prospective interview stage. That's going to be absolutely considered as part of the court looking at, is this relationship a genuine casual relationship? So you need to be very careful, if it is a casual role, that is reflected in all your discussions with candidates up until the point of them signing a contract and then moving forward. Having a written up-to-date employment contract consistent with the new definition, absolutely critical. Developing a system for ensuring you're giving employees the information statement as required is going to be really important, and making sure you're ticking that box, as well as making sure relevant managers are kind of trained in the new casual conversion notifications and know what to do when that process is initiated by the employee, so you can jump on it and make sure you're kind of ticking the boxes. So that's all from the casual employment perspective. And now Stephen is going to talk to you all about the right to disconnect, which is a very hot topic at the moment. So
absolutely. Thanks so much, Savannah. And the casual issues have prompted a whole host of questions, which I have been beavering away answering, and Savannah will jump in and have a look at some as well. If we don't come back to you, we can follow up with you at the end. But in the interest of moving on, the right to disconnect is probably the most well-known of the new laws. Having said that, there is so much misinformation out there in the press around these laws. I've been sort of following a number of news articles, and particularly in the popular press, the information that is out there and comments that are being put on articles by people are very misleading about how this works. And so it's very important to keep these laws in perspective and to understand how they work. So very importantly, the new law of the right to disconnect took effect on the 26th of August this year for large employers. For small businesses, and under employment laws, a small business is a business with fewer than 15 employees. So if you are a small practice with less than 15 employees, these laws do not apply to you. They will apply to you from the 26th of August 2025, so next year. If you have 15 or more employees, these laws apply to you now. In terms of the number of employees, you need to count employees of your business as well as the business of any associated entity. So if you have a group of companies maybe operating different practices or different businesses, you need to count the employees in all of the related bodies corporate. So don't forget that. It's not just about the mere on-the-ground business itself necessarily. You also need to count regular and systematic casuals in getting to that number of 15 or more as to whether these laws apply to you now. If in doubt, give us a quick call and we can help you get on the right track if you're not sure about whether these laws apply. So what do they mean? It is not unlawful to email an employee out of hours. It is not unlawful to phone an employee out of hours. What the new laws are doing are giving employees a right to disconnect from work, recognising that in the modern workplace with modern technologies, we are all, thanks to iPhones and all that sort of stuff, much more tethered to our jobs than we used to be back in the day when we would leave work at 5 o'clock and not hear from the workplace until the next morning. What these laws are doing is giving employees a positive right to refuse to monitor or read or respond to attempts to make contact with them by their employer or by a third party, so by a client or a supplier or a patient, whoever that might be. And the employee has that right to refuse that contact, provided that the employee is not being unreasonable in refusing that contact. So there is no limitation on your ability to be working at night and send an email out to an employee in your team about something that needs to be done the next day or whatever it might be. So you work as you need to work. In terms of, though, needing to initiate prompt contact with an employee, employees can switch off, provided that they are not being unreasonable in doing so. So it's actually, the law looks at the employee's reasons for not answering the urgent phone call or the employee's reasons for not answering the urgent email or attending to the urgent business need outside of their working hours, and looks at whether or not that refusal was unreasonable. And where it is unreasonable for the employee to refuse to accept that contact, then that would be an area where the employee would be potentially exposed to disciplinary action for not doing the right thing in terms of their obligations under their employment towards their employer. So again, you are not prohibited from contacting or attempting to contact employees outside of their working hours. Obviously, we shouldn't be just willy-nilly contacting people and insisting upon prompt contact outside of hours. If you are simply sending emails to clear your to-do list, to let people know what they need to do the next day or so on, that's completely fine. Where issues are going to arise is going to be where we're looking for people to engage with us right away. Now, what the new laws that are reflected in the Fair Work Act and also in amendments that have been made to all of the modern awards. And so for most of the people on the call today, we know that we are your medical practices and allied health practices. And so the Health Professionals and Support Services Award is your principal award when it comes to administrative staff, or you might have nurses covered by the Nurses Award. All awards have been varied to now include terms relevant to the right to disconnect, which lives holistically in the Fair Work Act, our principal employment legislation. So do have a look at your relevant modern award for relevant employees to make sure you're familiar with the new terms that have just gone into the awards dealing with this right. What the legislation tells us about the right to disconnect and whether or not an employee may reasonably refuse contact out of hours, the legislation sets out numerous factors that are relevant to take into account. And so they include the reason for the contact or the attempted contact, how that contact or attempted contact is made and the level of disruption it causes to the employee. Are we phoning? Are we emailing? Are we phoning a work phone? Are we phoning their personal phone or their home line, whatever the case might be? The nature of the employee's role and their level of responsibility is a relevant factor. And it's probably one of the most important factors when we look at this issue of the right to disconnect as to whether or not an employee will be unreasonable if they refuse to respond. And so a manager is naturally in the sort of job where they may be more likely required to make contact or deal with urgent issues arising out of hours than a low-paid junior employee in a very basic sort of role. It's also relevant to look at the employee's personal circumstances. So classic things like carers' responsibilities for their children, etc., will be very relevant. It's also relevant to look at whether the employee is being compensated for or being paid extra for either remaining available to work outside of their ordinary working hours or for working additional time outside of their ordinary hours. And so what that does is give us a bit of a clue to one of the important things that is a practical thing to look at in terms of managing this issue, is that where you do have an employee who is employed in a managerial role, whose duties will reasonably include the need to sometimes make themselves available outside of work hours to deal with an urgent client issue, to deal with an urgent patient issue, to deal with an urgent matter involving the workplace, to be noting that the employee's remuneration and their terms of employment have been set, taking into account the right to disconnect and the need for that employee to, on occasion, respond to us reasonably outside of their ordinary working hours where it is something that we need them to do. And so an employee who is maybe paid an on-call allowance under an award, for example, specifically to be on call, to be returned to work at short notice if the need requires, that would be a relevant consideration for that employee. That would mean that, well, where you are rostered to be on call, you're receiving an on-call allowance, you know that we might need you. And so it is more likely that it would be unreasonable for that employee to refuse contact or not respond to our attempt to contact them outside of their ordinary working hours where they're specifically really receiving that allowance, or in the case of a managerial employee, to not respond when they understand that the terms of their employment, including the salary they're paid, the duties and responsibilities of their position, include the obligation to be available where it is, genuinely required. It is always going to be a question of fact in the particular circumstances of each case as to whether or not an employee will be unreasonable in refusing to accept contact or attempted contact by you or a client or supplier outside of their ordinary hours. The critical legal risk for an employer around the right to disconnect is that it is now a positive workplace right that every employee, from your CEO to your cleaner and everyone in between, has. And it is unlawful to take adverse action against an employee for exercising the right to disconnect or for merely having that right or potentially exercising that right to disconnect. And so we can't be subjecting an employee to any detriment in their employment for reasons including their ability or their actually exercising that ability to disconnect from work. Again, it always comes back to the job, the reason for the contact, and the various factors that I pointed out as to whether or not the employee's refusal will be unreasonable. So it's unfortunately one of those lovely legal concepts that is all expressed in the negative, which in terms of looking at whether refusal is unreasonable. And so it makes things inherently confusing. And I think that is one of the reasons why there is so much misinformation out there generally in some of the popular press pieces that I've seen in the recent last week or so around this right to disconnect, as to why people are thinking that they can not respond to anything. And what I've certainly seen, including for a client just this last week who we've been helping in relation to this issue, is that employees have been saying it's illegal for you to contact me outside of hours. And that is absolutely not the case. It is not illegal to contact employees at any time. The issue is, like Savannah was saying in relation to casual employment laws, the best protection is really to sit back and think, well, do I really need to be engaging with this employee right now about this particular issue, or is it something that can wait? Where I'm asking them to be responding to me. So in terms of, I suppose, ensuring compliance with this right to disconnect, as I said, I think it's a very helpful thing to actively consider when you will be needing an employee to respond to out-of-hours contact from you or from a patient, a supplier, a client, whatever they might be, or if the response can wait. Again, if you're just clearing your to-do list and it's just like, hey guys, for tomorrow, can you do this? There's going to be absolutely no issue. But where something is happening and there is some urgent need in the business, if somebody has been rostered to be on call to come back, well, then that would be the person who you would obviously be reaching out to in the first instance to be asking them to come back to work. If you are aware that a particular employee is dealing with some, particularly difficult or challenging care responsibilities, their child is very sick, they've told you about that, and they're rushing home to take them off to the doctor or some other appointment, you might consider, well, do I need to be getting this person to be responding to this urgent issue, or should I maybe reach out to somebody else in the first instance? It's quite a common sense sort of approach that is really going to be the way for businesses to manage this issue and to deal with, questions or concerns. It is certainly very important to be reviewing your template employment contracts, particularly for employees who you anticipate will be in roles that will be needing to respond from time to time to urgent requests to do work outside of their ordinary hours, and be clarifying in those contracts, maybe in position descriptions, the expectations of the role, noting that it might include the requirement to reasonably respond to out-of-hours work requests from time to time, noting where compensation is being paid, where rates of pay have been set, taking into account things like the right to disconnect and the need to be connecting positively with us from time to time where urgent needs arise. I think it is going to be very, very important to not jump to discipline or take any adverse action or particularly disciplinary or performance management action against an employee who has asserted that they have exercised their right to disconnect without seeking legal advice. It is a complex area. There is a lot of misinformation. I've seen that coming back at a particular client we've been helping just this week. So don't jump to take action against an employee who you say has unreasonably refused contact with you. It's going to be very important to understand the circumstances of that employee and what actually happened, and as to whether or not it was unreasonable and so potentially misconduct for that employee to have not responded on that particular occasion or to have refused response on that particular occasion. So please do ensure that you are getting legal advice on a case-by-case basis before jumping to take any adverse action against an employee. And very importantly, I think, educate your employees around the right to disconnect. As I said, there is certainly a lot of misinformation in the media. And so people are misunderstanding this law. What we've seen is that people are interpreting it as a law saying that it is unlawful for the employer to contact the employee at all. That is not true. It is about everybody thinking about their rights and obligations, as well as the needs of the business that supports all of us in terms of whether or not they should be engaging reasonably outside of hours. So it's a very interesting new law that's come into effect. We are yet to see any decisions of the courts. Obviously, it's literally a week old, this law. It will be very interesting to see what happens. Disputes are almost certainly going to arise in relation to this area, and most likely in relation to lower paid, more junior employees who are being asked to connect outside of hours. I think we will see that it's probably going to be business as usual for most professional employees and most managerial employees, where the obligations of the role are clear, that you do what you need to do, and that person can make a reasonable assessment as to urgency as to whether or not they need to engage. But really, I think if you are looking to require engagement from a lower paid, lower level employee, you probably should be stopping and thinking, hang on, do I really need this person to jump now? Because that's what this is all about. Or is it fair enough that they disconnect and we pick this up tomorrow? Or can somebody else do this? How urgent is it really? Where those disputes will arise, there is scope for either the employee or the employer to make an application to the Fair Work Commission for the Commission to hear a dispute in relation to the right to disconnect. And that goes both ways. So an employee who is being, in their view, unreasonably required to connect and to make contact out of hours could go to the Commission seeking orders that the employer stop that particular requirement in that particular circumstance. But equally, an employer can go to the Commission for an order that an employee not unreasonably refuse requests to connect. So it'll be very interesting to see how those decisions unfold. In the first instance, you should always be seeking to resolve matters at the workplace level. And one of those, fundamental truisms that, communication is going to be one of the most important things that you can do with all staff to make sure that legal risks around the right to disconnect are minimised. Maintaining open lines of communication, letting people know when something out of the ordinary is happening and, hey guys, we might need to all jump in here and help out, all hands to the pump, whatever it might be that is required. Keeping those lines of communication open, listening to people when they do have genuine reasons as to why they cannot potentially connect outside of hours is going to be a really important point. So a really interesting one to watch this space. As I said earlier, for those of you who are larger businesses, so if you have 15 or more employees, these laws apply to you today. If you are in a small practice, the laws do not technically apply until next August, the 26th of August, 2025. So you have a little bit of a breather, but we have also seen, the publicity out in the world is not sort of making that distinction. And so you may well see people pushing back around this issue, even if it's not technically applying to you. So still, as a matter of, I suppose, best practice and good HR management, good people management, these sort of factors are factors that you're going to want to be taking into account more generally, looking at broader legal compliance and legal risk issues like discrimination on the basis of carers' responsibilities, for example, that has been and always will continue to be a legal risk around exactly this sort of stuff. So keep it all in perspective. The next major change that I would like to take you through today is changes to independent contractor laws. And what this fundamentally is about the distinction at law between who is an employee and who is an independent contractor. That has been a source of dispute forever, and it's an important legal issue because employees have certain important legal rights under our heavily regulated workplace laws, and independent contractors do not have access to those rights. Critically, various claims around termination of employment and rights to things like paid leave is one of the very important distinctions, as well as statutory minimum rates of pay, the benefits of award terms and so forth. And so what the Parliament has done is take us back to the future in relation to looking at the law of who is an employee versus who is an independent contractor. The High Court a couple of years ago handed down a very important judgment that said that the law of the contract is king when it comes to determining if you have an employee or an independent contractor, meaning provided that you have a valid independent contractor agreement and it says you are a contractor, I am the principal, then that will be a valid legal independent contractor relationship. Similarly, an employment contract saying you're an employee, I'm your employer, would be a valid employment contract. That High Court decision was very significant because it undid years of federal court law that looked at the conduct of the parties and the reality of the working relationship to determine, along with the terms of the contract, whether a person was really an independent contractor or an employee. And what the federal Parliament has done is sweep aside the High Court's decision by amending the Fair Work Act to include, for the first time, a new statutory definition of employer and employee. And that definition says that in determining whether or not a relationship of employment is on foot, we are to make an assessment based on the real substance, the practical reality, and the true nature of the relationship between the parties. And so that requires us to look at the totality of the working relationship. That includes the terms of the contract. So it's always critically important to have a good, legally compliant employment contract in place, or a good, legally compliant independent contractor arrangement in place, so that you have a good, solid contract. But in addition to that written contract, we also need to critically look at how the parties conduct themselves in practice, how that contract is performed in practice. And so you cannot rely on a beautifully drafted independent contractor agreement to say that someone who is really an employee at law, by applying this new legal definition of employer and employee, is a contractor because I have a beautiful independent contractor agreement, if we are not conducting ourselves in the workplace in a manner consistent with an employer and employee relationship, or a principal and contractor relationship. And so the conduct of the parties is key. And so it goes back to these multifactorial tests, like we mentioned at the beginning, and like Savannah has touched on in relation to the casual employment laws. These are now coming back into fore with the laws in relation to who's an employee and who's a contractor. I think that what we're going to see for medical practices and for healthcare practices and businesses of a like nature, it should be, these legal changes should have very little practical impact. It would be very, very, very rare, and something that you should be seeking legal advice on if you are employing any administrative employees as contractors, or any nurses as contractors, a practice manager as a contractor. That is possible potentially, but it will be very rare in practice, and so something that you should be very cautious about. Most administrative staff, nurses, are going to be employees by virtue of the work they're doing, by virtue of the control that the employer naturally exercises over those employees in relation to the standards of work and the type of work that they are required to do, that they are often working alongside other employees performing exactly the same tasks. A true independent contractor is somebody who is bringing some particular expertise to the table, who is running their own business, who is contracting to you for you to pay a price to them for their services. A doctor is an obvious candidate for being an independent contractor, and a doctor can validly be an independent contractor. A doctor can also validly be an employee or work under a services and facilities agreement. There is a mixed bag out in the community as to how doctors are engaged. The vast majority of doctors in the private sector are engaged under services and facilities agreements, meaning that they are engaging your practice to provide services and facilities to them in the conduct of their own independent medical business. Those doctors on true service and facility agreements are not independent contractors. An independent contractor is effectively the 180-degree opposite of a doctor on a services and facilities agreement. A doctor on a services and facilities agreement is engaging your practice to provide them services and facilities, and a contractor is someone you engage to provide their medical services to your healthcare practice. So they're two different things. So don't confuse your doctors on services and facilities agreements with independent contractors. A doctor can, though, validly be an independent contractor. It will depend on how that individual is working and running their own business, and how your practice is operating itself. And that will give rise to very important issues around considerations of topics like payroll tax that have separately been a massive issue in the industry, and that are a whole different topic, but there'll be relevant considerations there. But for the majority of practices where you are employing your nurses, employing your administrative employees, these laws are not going to have any real impact on a day-to-day basis. And again, do take advice if you are engaging any administrative or nursing staff as contractors. That would be very important to make sure that everything is compliant in that respect. For an independent contractor who is validly engaged as an independent contractor, there is scope for that, a contractor who's a high income independent contractor, and that is someone who earns over $175,000 a year, to opt out of the statutory definition of employer and employee. So what that means is that if you are, for example, engaging a doctor as an independent contractor, and you will be, that doctor's earnings under the contract will be $200,000 a year, you can ask that doctor to opt out by giving certain notices that comply with the legislation to opt out of the statutory definition of employment, so that the considerations relevant to the practical working relationships between the parties and how those relationships may or may not vary from the terms of the contract, we can opt out of that applying for that person, which means that they would firmly sit in contractor land without you having to worry about whether or not they really are an employee by way of the conduct of the parties over the years. The little kicker that comes with that, though, is that that independent contractor can give you notice at any time to revoke the opt-out notice that they have given. So even if that person agreed to opt out of the consideration of whether or not they're really an employee, that will work for as long as that remains in effect. But that person could turn around at a later point for whatever reason and say, I revoke that notice, therefore I fall back into the statutory regime. Therefore, the conduct of us as me as a worker, you as the principal or employer, will come into question and may well become or be treated as an employment relationship. If you are, in fact, treating that person as an employee, you are controlling the work they do. You are controlling when they come and go. You are controlling the standards to which that work is performed. Things like that that will tip the balance of whether someone is an employee or a contractor into the employee camp. So the value of those opt-out agreements is a little bit questionable ultimately for people who are eligible, and that is again only high income contractors. A very interesting reform that has come into effect just last week in relation to contractors is that the Fair Work Commission now has a new jurisdiction to hear an unfair contract claim for an independent contractor. So an independent contractor can go to the Fair Work Commission to make an application that the Commission deems a certain term of their contractor agreement that goes to workplace rights an unfair term, taking into account a whole range of factors, including the relative bargaining powers between the two parties, whether any terms are considered harsh, unjust, or unreasonable, factors like that, to potentially say that, look, that term of this contract is unfair, and so I'm going to change that term. That is a very interesting jurisdiction. It's hot off the press, brand new. There are no cases yet where an application has been made to the Commission, where any orders have been made. It's very much a watch this space, but it is a jurisdiction that certain contractors will be able to use to call into question the terms of contracts that they've been entered into, where those terms can be found to be unfair. And so it's going to be very important to be reviewing your independent contractor agreements to make sure that they are specifying very clearly the terms of the engagement and making it clear that the parties have genuinely bargained for the agreement that you have reached. So we always want to have an up-to-date written contract with all independent contractors. While these legal reforms to the Fair Work Act have knocked out the High Court's judgment to say that the contract is king, the contract remains critically important to the assessment of the relationship. What is most important is that you ensure that you are not just getting us lawyers to draft you a beautiful contract, but that you are actually operating your practice in terms that are consistent with that contract. And so you want to make sure that working arrangements on the ground are in practice reflecting the terms of the independent contractor agreement. The highest risk category of contractor is always going to be a contractor who works exclusively for you, who isn't the local electrician running around town servicing a whole number of clients of which you are just one. The person who works exclusively for you, who does work alongside employees performing the same or similar work, that is going to be a very high risk scenario. A true independent contractor is bringing some particular skill or expertise to your business that you don't have among your current workforce and that you need to meet the needs of your business. There are these opt-out arrangements that are available for high-income contractors that might be worth looking at. But again, looking at the terms of your contract agreements and practical working relationships on the ground is going to be a really key thing to help ensure compliance in this space. I'll pass you over to Savannah to discuss the final of the big topics we wanted to talk to you about today.
Perfect. So just do this one really quickly because I know we're almost at the end of our time. But so from the 1st of January 2025, there's going to be a new criminal offence in association with underpayment of wages under the Fair Work Act. So it's called the wage theft offence. Effectively, wage theft just means underpayment of wages. So in February this year, there was already an increase to the civil penalties payable for underpayment of wage offences. And then in 1st of January next year, the criminal offence will be introduced. The criminal wage theft offence carries a maximum of 10 years imprisonment and or a fine of the greater of 3 times the amount of the underpayment if the court is able to determine that amount, or for an individual around $1.5 million, or for a corporation or a company around $7.8 million. So very, very significant increase in the penalties, and particularly for the criminal wage theft offence. Now, the criminal wage theft offence is around intentional underpayments of wages. So it's obviously a more serious offence than some of the civil provisions around underpayment of wages, and it's really going to be looking at the very serious underpayment offences. But I think what's really important here is, underpayment of wages has always been a very key focus of the government and the regulators in this area, and always will be. And so it's something that businesses always need to be taking really active steps to avoid any contraventions of payment of wages. I think one of the most common misconceptions that Stephen and I see in practice is people think that underpayment of wages really only occurs in situations where there's really serious exploitation going on. So, a cleaner being paid $5 an hour and not getting any breaks, etc. In fact, that's not the case. That is absolutely an underpayment. But what we see in practice is the most common instance of underpayment of wage offences that we see in practice is actually where employees are effectively given a set and forget wage, which might be above the applicable award minimum, as an example. But then employers don't think critically about how that employee is working relative to the terms of the modern award and whether they might be entitled to additional amounts like overtime, etc. And so where you've got someone, I think there's a common misconception that where you pay someone a rate of pay that is above an award rate, you can automatically offset any other monetary entitlements under the award, and you don't really have to look at the overtime provisions or the penalty provisions, etc., under the modern awards. And so I think really practices need to be actively looking critically to ensure that all employees are paid in accordance with the applicable laws, in particular having regard to the terms of the modern award. And so it's not enough to simply pay an employee, $1 above the award minimum and set and forget. You really need to be actively looking at how the employee is working. What would they be entitled to under the modern award if I paid them in accordance with the minimums, including any overtime, any allowances, etc. And then if so, if they what would they be entitled to, and does the rate that I am paying them actually compensate them for those entitlements? So while obviously the criminalisation of wage theft is really going to be looking at the higher level and very serious offences where intention can be proved, the civil underpayment offences are still in the Fair Work Act, have very significant penalties, and this is obviously an area where there's been increased focus, particularly by the regulator, the Fair Work Ombudsman. So really practices need to be kind of making sure that they're they're not falling foul of these laws, because they're very, very serious and they're taken very, very seriously. That's all from me. Stephen, I don't know if we've got time for any questions, but we've both been beavering away trying to answer as many as we can as we go.
Yes, thank you for all of the questions. We have tried to answer as many as we can. There are still some outstanding, so we will drop a note to those of you where we do have your details afterwards, just to touch base, and so to answer those issues. Thank you so much for joining us today. There is a scanner code on the screen for a link to our article addressing the laws that we've talked about today, and also a QR code to get in touch with us. We would be very happy to address any further questions that you have and provide any further support that we can. So thank you so much for your time. Have a wonderful rest of your day. Thank you.